Hi, everybody. Thank you for coming today. Welcome to our AI launch event here in Canada. We're thrilled to see everyone here. My name is Alexis Conrad, and I'm the Senior Manager of IP Business Development with Intellectual Property Ontario. We're here today because we had some really amazing partners that helped us put this event on. University of Ottawa, the Canada North team, helped us do so much for this event. We also worked with Queen's, we worked with Carleton and Algonquin colleges, and several industry representatives that help us get the word out, promote to their businesses that they worked with, and participate with this in their general ecosystem. We'd also like to take time to acknowledge that we're on the territory of the Algonquin people, who are the traditional guardians of this land. We acknowledge their long-standing relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. I will now turn to my colleague, our VP of IP, Geoff North.
I'm just here to give you a little bit of an overview of IPON. And the one thing that I'm constantly asked is, what is IPON? What do we need IPON for? We've got a bunch of other regional innovation centers. We've got Invest Ottawa. We got the tech transfer offices, everybody involved, federal programs. But IPON is unique. And just to give you a little bit of history, in 2019, the Ontario government commissioned an IP expert panel. And they wanted to look at the IP landscape in Ontario. They wanted to see where we were strong, where we were weak, how we could improve it. And one thing that they came up with, and I'm just going to refer to a few sort of notes that I sort of take from their report, kind of lays out where we are. IP and data are the world's most valuable business assets. And you can see right here, based on the S&P 500 market value, it takes up 91% of the value. And yet, what's happened during that same time is, if you see here, Canada's GDP has gone down compared to the US. It almost corresponds with how things have changed for the value of IP and data everywhere. And one thing that the report noted is the US has better aligned its economic policy infrastructure with knowledge-based and data-driven economic realities than has Ontario. Really, you can really see this pointedly with this next slide as well. Today, we're here for an AI launch, and you can see this. It's going back to 2016. This was in the report. But look at the filings. These are the patent filings by country. Here we have China, the United States, Canada is way down here. And there's a major correlation between patent filings, patent strategy, your IP strategy in general, and the health of your economy. And we're finding that more and more as we go on, and we're lagging behind. This was a good quote I took from the report. Canada is the world's open source factory for ideas. We create it, but let others commercialize it. Another one, and this is probably one of the core ones and why we exist. While Canada appears to have the human capital and infrastructure to support innovation, it falls short relative to other countries in investment in R&D, patent grants, and incentives to advance to the commercialization and sustainable operation stages of the innovation process. The expert panel, they made many different notes about where we were lacking, and here are a few of them. Ontario has a lack of support for patenting and expertise on IP, a low understanding of the importance of IP, and some institutions may not prioritize IP commercialization or a culture of innovation. Based on that, IPON was created in January of 2022. And here are the main objectives: to increase public access to services and resources in respect of IP, to support the development and protection of IP to improve the commercialization outcomes of research in Ontario, to advance knowledge and best practices in research, to establish partnerships within and outside Canada for the purpose of building capacity, and to provide advice, recommendations, and support to the Ontario government with respect to the development, protection, and commercialization of IP. Based on that, we've come up with what we think is a good way of dealing with the IP ecosystem in Ontario. And these are some of the products, let's say, that we provide. For our clients, and we are currently in a beta test phase right now, we're taking 40 clients from the medtech, auto, and AI sectors, and we're going to give them these different services. Once the beta test period is over, we're going to do a report. We're going to make sure that we're offering the top-notch services moving forward for scale-up, where we go beyond the 40 to, let's say, 150, 400, and possibly 1,000 clients and more, maybe down the road. That's where we're headed. But right now, we're offering up to $25,000 for IP services. That's if we determine what sort of patent filings you need, industrial designs, trademarks, and the like. We provide one-on-one mentorship programs. And that is both sort of on the technical IP side, where you've got your IP agents who are able to assist with your IP strategies and your IP filings, going forward, but also commercialization mentors. And these people can help you get to scale up and to commercialization, because ultimately that's the goal that we're looking at this time. Advanced IP education. This is something that the expert report made sure that we have to have in Ontario. We're going to have basic education. We're going to have micro-credentialing. And this will be web-based for one. When people take these courses, they're going to have a certain level of IP education moving forward, which helps in all aspects of our IP economy. We're providing IP patent landscaping. We can see where the white space is in the different sectors. We'll be able to tell you where your main competitors are. IP benchmarking for our clients that we bring in. This is sort of a mini audit, IP audit, where we're going to be able to tell exactly sort of the IP health of the clients in terms of their IP strategy, their filings, all the sorts of things, even open source software. Are they handling that properly? Based on the results of the benchmarking, that is going to dictate the mentorship, education, and other aspects. And then matchmaking. This is going to be a big part. This is where if we see that a certain client could use assistance in a certain way to get them to scale up and commercialization, we're going to be working with our partners, others, whether it's in TTO offices, whether it's different researchers at universities, whether we're working with our IRAP people, working with our IAC friends, whoever it is, to get up, towards commercialization. So in sum, just to give you an overview, we're trying to be the centralized resource for IP in Ontario that works with partners across the entire ecosystem. We're here to work with and help with the Invest Ottawas, the IACs, the IRAPs, the TTOs, to make sure that we're doing things properly, because often we're working in silos, right? We need to now start working together to make sure that we really get the SMEs in Ontario up to scale up and commercialization. We're
going to get started with our panel now, and I'd like to make a few introductions. First, to my left is our fearless leader, Peter Cowan. Many of you in this room have met Peter before. He's the CEO of Intellectual Property Ontario. He's a named inventor on over 70 patents. He's actively involved in the IP space and activities ranging from advisory to policy to operations and absolutely everything in between. Next, we have Liz Gray. Liz Gray is a patent and IP lawyer with Brion Raffoul. She has been working closely with AI companies related to their intellectual property and since about 2017, 2018. And thank you very much for being here today, Liz. And we also have Jeremy Henderson, founder and CEO of Stratotegic, an aerospace robotics company specializing in the flight coordination of unmanned stratospheric flight and advanced research and machine learning systems. And we also have Rafal Janik, Chief Operating Officer of a company named Xanadu. Many of us have heard of them as well. He manages business operations and leads organizational growth. He has immense specialization in commercializing deep tech projects and over 10 years experience in leading software and machine learning teams, both with large enterprises and high growth startups. And last but not least, we have Dr. Thomas Triplet, Senior Director of AI and Platform at Bluwave-ai. Leads their engineering team for clean technology, building innovative and practical solutions for the intelligent optimization of smart grids, fleet electrification, and to accelerate the transition to clean and renewable energies. So this is over to you now, Peter. And then after the Peter introduction, we're going to have some IPON updates and Q&A.
Thank you, Alexis, and thank you, Geoff, and the rest of the panelists. I really appreciate your time today. It's been an exciting time in getting IPON off the ground, and I think one of the pieces that IP Ontario and other IP organizations want to also make sure we provide is, support for the companies themselves. So we do have quite a few companies today here, and I think some of the panelists, I've been asking them to talk about their IP journey and where they bring their supports from and where IP strategy fits in their organization. So I think for the organizations that are boots on the ground and running to get to scale up, I hope that the next 40 minutes or so will be a great use of your time. So maybe I can just start it off and we can kind of go down the panel line, but just really interested to set the stage and hear about maybe where IP plays a role in some of your startup journeys and growth journeys. I know we've got organizations from the whole spectrum, from startup all the way to moving on to scale up. So I'm interested, maybe we can start at the end with Thomas and work our way backwards.
Sure. Thank you, Peter. So at Bluwave, Bluwave is a startup. So our journey is still early in the process, but we still have a team working, and it was very important for us to define a strategy very early on. Sustainable energy and clean energy is growing fast, and so to make sure that we protect our investment, it was very strategic. And it's also very important in terms of strategy to show investors that we're not yet another startup surfing on the AI wave. But we have real innovative work that is being done. And one of the best ways to showcase that is to protect the IP with patents. I was also, before joining Bluwave, I was also for many years at Sienna, which is a much larger corporation. Processes were quite different, obviously, a lot more resources. We had in-house lawyers who could help us. So the process was a lot more streamlined, but the overall process was in the end fairly similar. The motivation was a bit different. It was still a lot about innovation, but as a bigger company, lawsuits were a bit more of a concern. When you're a small startup, not as much. But in that case, strategic value of patents was also a lot more the defensive aspect.
Xanadu, maybe we're a little bit different. Our time to market, based on how deep tech what we're doing actually is quite a bit longer than for a lot of AI companies. I'm sure there's quite a few AI companies that are still very much focused on research. And for you especially, I would say that IP will be the number one way that potential investors will value your company in the early days. It becomes very important to build that patent portfolio, not just realistically for making sure you have the freedom to operate, to bring your product to market, but just to show what the vision and the value is before you have revenue coming in and those standard metrics that investors look for. That being said, it's incredibly challenging and very taxing on technical teams to actually generate the filings. Doing the actual innovation is maybe not straightforward, but then taking weeks of time to work with lawyers in order to actually file a patent does slow things down quite a bit. So there needs to be a bit of a consideration one way and the other of how much you actually want to do. In our space also, we have a couple giants. I mean, IBM is very much focused on quantum computing. They continuously break records in terms of the number of patents they file. And the patents that they file range from being incredibly well thought out and really innovative to what we call like the round corners of quantum computing. The one click to deploy a quantum job type of patent that realistically should have never been granted, but based on their size and the amount of pressure they're able to exert, do pose a risk for us. So being able to have a portfolio to protect yourself against those types of threats is also really important, even in the early days of operation.
Good morning. I'm Jeremy Henderson from Stratotegic. And like we said, working with aerospace and robotics, it's the last couple of weeks have really changed our industry. So we develop artificial intelligence for stratospheric balloons. Yeah. So, and I did not fly over China. It was not my balloon, nor were any of them. But it's interesting. Like the last couple of years, when we started this, my background is 22 years in the Air Force, the Canadian Air Force. So I'm not an engineering background, but I'm more the aerospace background. And it's been interesting because what we originally sought out to solve through AI to figure out advanced navigation for stratospheric balloons, it's now kind of dwarfed into, okay, so you can navigate balloons. Now you can navigate unmanned drones. It's not just for the air environment, whether it's an air current or sea current. The algorithm knows no difference. So from an IP perspective, we really had to loosen up and not pigeonhole ourselves into a patent process for that. So I work with Queen's Launch Lab. They've been really helpful so far. And it's kind of explaining to them, okay, so we got to make sure we don't pigeonhole to one environment because it's such a broad use patent that we're kind of looking for that it really had to be sorted out. And it's been really successful with the help so far from both those organizations, Queen's and Launch Lab so far, and hopefully with IPON in the future.
So thanks. So maybe just a follow-up question for one or two or three of you. You all talked about IP being an important part, has some value. How do you articulate that value to your C-suite, your board, your investors, your funders in the organization or funders of your company? Trying to, for some companies that are in early stage, they're trying to think, okay, we know we need to do IP, but how do we link that to a value-based discussion about where it's going to put us in the future? How do you more pointed question, how do you rationalize spending engineering time on the IP file when you've got to get back to engineering? It might be a different way to think about it.
I mean, in our situation, it's more rationalizing it to the engineers more so than to the C-suite. But realistically, the pressure comes externally. For us, it's been pretty straightforward to motivate the fact that we need large amounts of capital to operate, to deliver on our mission. And we can't do that without venture capital or some sort of external investment. That pressure is coming from investors. Even if we go to our board and ask them, hey, can we file no more patents? Like we could do trade secrets wholly. They know that the value of our company is still very much wrapped up in that. So that pressure is coming externally towards us. The real challenge is to figure out how to work with external partners, whether it be law firms, whether it be consultants, in order to remove the pressure as much as possible from our engineering talent. Communicating the value has, at least in my case, never been a challenge.
Yeah, I have the same experience here. Communicating that to the executives is usually not a problem. The challenge comes with conflicting deadlines. When you have customers, you need to deliver something. That's kind of when it becomes a challenge. And executive team is usually on board, but the biggest challenge is to have the middle management on board as well, so that they can prioritize time of engineering to focus on this kind of stuff. Because if they don't do it now, 6 months later might be too late to do it. And 6 months later, you're going to have other priorities anyways.
So for myself, I don't really have to convince myself the importance of the IP. From my company's standpoint, I've got a large engineering intern team at Queen's, 8 interns now. But on the business side of the house, due to a lack of VC so far, it's been myself. And that's been a challenge because we have multiple IP that we want to patent, different stages of development already, but I already see the value of these, and some of them are easily global patent value, but it's getting the priorities. Like part of our business is we do aerospace control, flight coordination. So I run air traffic control for stratospheric unmanned aircraft around the world. So over 6 continents so far. And it's finding the time to take away from that and business development, and then also putting it towards focusing on enacting the IP strategy.
Great. Thanks. And we've mentioned a few times, you mentioned patents, trademarks. Would love to hear, and Liz, maybe you can start us off. How do you actually think about IP and AI, and where does that come together? People often think about patents, and I'll maybe just give one comment. The slide that Geoff put up about the patent volume going up. There was a new post I saw on LinkedIn the other day that's been updated, and those numbers are, I think the slides like this, and the numbers go up to here, and they're all coming from Chinese-based organizations. So there's been quite a shift in that. So Liz, from your perspective, how do you think about companies protecting AI, and where does that fit in?
Well, I think, so one thing that we're still hearing from companies in this space a lot is that we don't do patents in AI. It's just all basic research. And that's not true. It's not true. There's a ton of patents in this space, and they're mostly large multinationals. They're Google, they're IBM, they're Chinese entities. And so a lot of that early ground that I think, as Rafal was saying, is like, maybe some of them aren't the strongest patents, but they were early, so they're there. And now you might have to know what else is out there. So I think from the AI side, we often see just a lack of interest in patenting, especially from SMEs. And then it's difficult to establish that this is something that you need to be thinking of as, even from the earliest days. You don't necessarily, you don't have to patent everything. You probably can't patent everything, and you do need to strategically prioritize what you want to focus on. But we see this lack of strategy showing up very often, and whether where you're going to focus is patents or trade secrets, it really just needs to be approached in a careful way, knowing what your business goals are and knowing what you can do in the landscape that you're operating in.
And the rest of the group here, how do you think about, when you think about IP, what are the different ways, maybe internal processes, trade secret paths, that you think about layering together to protect the value piece?
So one of the difficulty in AI is detectability. Sometimes it's sometimes not very easy to detect someone is infringing your patents. And so when you have reviews internally to decide whether it's a patent, trade secret, or something else, it's important to see what's new and what can be detected. And in some cases, patent might not be the right thing to do. Maybe a defensive publication or a scientific paper might be the right thing to do. So that way you cannot protect your IP, but at least you make sure your competitors are not doing it on your behalf.
One, I hate trademarks. All our software packages are named after Beatles songs, so it's been a super challenge to get those trademarks. Actually, the biggest issue has been with Strawberry Fields. And if you ever put the name Berry in anything, our friends at BlackBerry will come after you, guaranteed. No, but more seriously, for me, it's always a focus on what is the actual goal you're trying to achieve with your patent portfolio. And early on for us, it was very much about that value generation. But as it gets further along, it's now understanding as we come to market and very large competitors or even non-operating entities hold substantial patent portfolios. Are we able to defend ourselves? Are we able to cross-license in order to have the freedom to operate? This is going to become more and more important. So as much as we'd love to keep things trade secret, and for us, realistically, from a pure protection point of view of our invention, that is more than sufficient. It might prevent us from being able to do other things as people protect other aspects of the field. So we have a very forward-looking vision for our patent strategy, mainly because our technical roadmap is so long. But I definitely encourage everybody to also think kind of from the beginning about how long is it going to take you to get to market? Once you do get to market, what are you going to need from your IP in order to be able to actually commercialize your development?
Yeah, I look at it as well from not just a competitive background, but strategic as well. Like we'll have to take, like right from the beginning when we started the research, we had to take a black box look at this and say, what can we keep secret? Because this could ultimately be a very strategic platform that could be used by adversaries. So that's something at all costs we can't allow to be used, and we also just don't want to publish it. So that's something that we really had to take into consideration. And as we've seen in the last few weeks, that's a real concern.
And you mentioned cross licenses, so maybe we can dive into that a little bit. And Liz, I'd love your thoughts as well on where data fits and data protection, and how you need to think about that from a strategic point of view. Cross licensing and even just licensing as a subcontractor. How you protect your access to future data. So, Liz, you might have some thoughts to jump us off with.
So, of course, we need a ton of data for training every model, basically. And typically, edge cases are really hard to come by. We still get a lot of questions on a fairly regular basis, like, can't I just do web scraping? Can't I just take information from the internet? Isn't that fine and safe? And of course, it's not really. There's all sorts of risks there. There's copyright risks, privacy, IP ownership, just a whole bunch of potential problems that you're exposing yourself to when you're doing that. But then the most common other approach is data licensing. And we also see like a lot of SMEs who just don't necessarily know what they're getting into when they sign a data license, because there are frequently like IP ownership provisions in there. If you take data and you train a model on it, and the resulting trained model is based on that data, who owns the resulting trained model? So in some cases, we've seen clients who've maybe without realizing it, given away rights that they didn't know they were even going to specifically have. They thought they had that model free and clear, but they used data that wasn't accounted for properly. And I think we're really going to see data licensing and data ownership issues come into play so much more in the next few years than they have been yet. And it's really critical to be careful about what you're bringing in and what you're giving away, and just knowing the trade-offs that you're making.
Any thoughts on the data or the licensing side from the rest of the panel?
I think from the data perspective, it's also interesting when you have data from different customers. Question is, do you train one machine learning model that includes data from many customers, in which case one customer might not be happy to know that his data is used to benefit potentially his competitor. So it's really important to have first a license to use the data. Copyright is important, and we've seen that with generative AI, like ChatGPT, DALL-E. Those algorithms have been scraping the web for data, and now we're kind of starting to see lawsuits about companies not too happy to see that their data was used by OpenAI to build this AI model. Kind of the same with customer data. As you have your own algorithms, you train that on customer data. Typically, you would own the algorithm, but do you own the resulting model as well? And if you do that with multiple data sources from different customers or even public data, who owns the model? And what if, even if you own the model, what if they retrain a bit? So you might have a model that is very similar but a bit different. So licenses is a bit of a challenge in AI.
Just on the customer part, as an early stage company, and definitely we faced this several years ago, it's great when you get your first contracts, but you have to be so careful with what those contracts actually say about not only how you use the data that might be resulting from them, but even broader IP implications of what products are developed downstream from that. Same thing from the supplier side, might be a little bit different, but we work with many fabrication facilities around the world. And if you don't push back, they have some pretty tough IP considerations that can really have a big impact. So often it's worthwhile to actually walk away from what looks like a really great deal that can get you, a good amount of revenue through the door. but it could have a really big impact on your ability to own the IP that was generated downstream from that.
I'll maybe use this time as a plug for Geoff for IP Ontario. I think one of the pieces when we set up IP Ontario was to actually really think about the data piece, the contract piece. I think this is where a lot of early stage companies need sophisticated legal support, and that's one of the allocations in our funding. So we'll talk about that a bit later. But the data piece always comes up, and I know there was something called the Montreal Data License that was put out. I don't know, Liz, do you know about it? You can talk about it for a
Right.
few minutes.
So the Montreal Data License, it's a standardized data license format. It was created in, I think, 2019 by Element AI, which was active in Montreal before it was acquired. But so this data license just offers like basic terms and basic definitions, and it's a very good reference tool to use and adapt to your needs. The idea of it is sort of similar to an open source license in that it's standardized and predictable, but it has, in terms of ownership, it is more clear on ownership than most open source licenses, which do contain follow-on obligations, but don't have ownership in the same sort of sense.
Yeah, I was looking at it last week. It's actually archived since the acquisition, so you have to get to it through the Wayback Machine. But if you're looking for a link, please send me a note. It's really interesting. I think I find it basically asks yes/no questions, and it gives you the different contract phrases. So those that are in the early stage, it's a great reference tool as a starting point before you meet with counsel. So maybe we can jump forward a bit. I'd really be interested to hear about how you look forward and reduce IP risk and freedom to operate. So the FTO is always a big issue, making sure that 5 years down the road you won't have IP problems with a potential company or competitor, and interested in some of the practical things you do inside your organizations and Liz that you see across your commonality of your clients that they actually put into practice inside.
For ourselves, we've done some funding through MyTax already, and the way MyTax is, they made it easy. It was all the IP is 100% owned by the company out of the University at Queen's, so it was straightforward. Some of the other universities may not be that case. I've worked with another one, and it was negotiable, and we came up with a decision that the IP could be used for learning purposes, and if they want to commercialize it, then it would be another discussion. But such as that, and it's just, and again with other contracts, like Rafal was saying, you have to be careful what the end benefit is, and at the end of the project, who the IP belongs to, whether it was dual funding throughout the project, and you got to make sure you retain that.
I mean, from a pretty practical sense, just to follow up with what was just said, definitely engaging with a university or wherever the original IP was created as early as possible is really important. It gets tougher and tougher as your business moves forward to negotiate rights to IP that might not belong to the actual company, even though you might be the inventor listed on that patent. The other one that from a practical sense definitely helped us out, again, we had a technical founder, we had a small technical team that was really focused on, in the early days, was going through a series of incubators. So DMZ and the Creative Destruction Lab in Toronto were really helpful. Even though they might not give you everything you need, they at least start providing you with the questions that people are going to be asking you further down the line, and then allow you to go and engage with folks like IPON to actually start resolving those issues. We don't necessarily do full freedom of to operate scans. Those, of course, also pose a risk, especially if you're early in the development stage. But we do like to benchmark ourselves against our competitors. We know who they are. We keep very close tabs on what they're filing, how many patents in what specific areas or sub areas of our industry. We keep a very close eye on that. And then, though we've built a team internally, that's actually now pretty substantial, we do still very heavily rely on many external partners. And I'm not sure where this kind of advice came from internally at Xanadu, but we definitely have the idea of not putting all our eggs in one basket. So we tend to work with always multiple external partners to make sure that we can kind of scale up and down as needed with the volume of work that's actually coming out from our engineering team.
Yeah, from my perspective, we've had many collaborations with universities. One thing that's important for universities is usually to publish the work in scientific journals, and obviously this is great to disseminate information, but from an IP perspective, that could potentially be a risk. And so when we have early discussions with the professors, we try to discuss that upfront so that we kind of retain the right to patent before they publish to journals or conferences. We also have to kind of go back on the risk, but for us the biggest risk I see in terms of IP is to not do it. And so once you have a strategy at the executive level, it's really important you also have an IP culture in the company to make sure that whenever you have projects, you make sure you do your due diligence to review what can be potentially patented, and make sure you allocate time for that. Make sure you have the proper clauses in the contracts to support it. If you go outside of Canada, for instance, in Europe, privacy laws might also potentially be an issue with the way you use the data. So make sure that you have proper agreements with local companies, and make sure you're aware of local regulations as well, because there are things we can do in North America, we cannot do that in Europe or other regions.
And in reference to that, in terms of freedom to operate, knowing where your competitors have patent holdings or other holdings is really critical, because of course you might have freedom to operate in the US, but not in Europe or vice versa. So you really do need to pay attention, not just to your closest competitors, though that's absolutely critical, but take a wider view as well and keep that in line with your goals. Because we also hear this sort of, and Rafal sort of mentioned we don't want to know too much, because if we know too much, then we have to disclose it. But I would say that that's also a risky decision to make when you're a small medium enterprise, especially if you have one main core technology, because if that is going to be your absolute focus, and it turns out that Google, for instance, or IBM has maybe a very large family or portfolio of patents that potentially read on that technology, that's something you want to know in the early days before you commit yourself entirely to it, especially because if some of those patents are broad or vague or might be easily taken out, it's much easier to file a protest at the patent office and say, I think this is a bad patent, look, than it is to fend off an infringement lawsuit 5 years later.
So maybe just to dig into that for a brief question, I think some companies at early stages, they're maybe even if they're making a few $1 million in revenue, they aspire to compete against the IBMs, the Googles of the world. If you look at the patent filing counts, they're in the top percentile in North America. So how do you, how do you advise companies at this early stage, knowing they're going to have to compete against someone that literally has 10,000 patents at their disposal that could kill them in through a lawsuit if they wanted to do it? Like, what is the strategy behind that? The planning? How long do you think they need to take about it, and take to put that into action and things like that?
So I think in that case, the core idea is to focus and to really know what you bring that Google or the big players aren't interested in bringing. So they might have a variety of patents, or they might have the area protected. They might not have your specific niche, and that might not be a business model that they're interested in. And it's also something, every case would be different, but it might be something where a license would make sense or some sort of joint venture. But one thing that we've seen over and over is get filings on file before you talk to large companies, because they don't have your best interest at heart. They have their own best interest at heart, and they aren't necessarily going to be thinking about your protection. So it is important to know what you need to work on. And in terms of timing and how long that can take, it might be a longer process if there are already a handful of very broad patents. You might need to take longer to refine what you need to figure out. But basically, there's absolutely an uneven playing field, a difficult, uneven dynamic, and every negotiation in that context is going to depend on exactly what you're doing and exactly what they have, but it's not impossible, is the thing.
So maybe just there are organizations now in Canada, kind of around the world, that are looking to build patent portfolios that you can become a part of, join, to have a defensive portfolio in case you do face a lawsuit. I would make the argument that definitely in quantum and probably in AI, if you took patents at their face value, it would be very difficult not to be infringing at least some subset of patent from these organizations. Some of them are overly broad, should have never been awarded. And, we know ones where it's the equivalent of submitting a job over the cloud. And it's like, this is something that's existed for long before this patent was filed. It should have never been awarded, but everybody currently operating in the quantum space is infringing on this. Our strategy really is to make sure that we have enough of a patent portfolio to show, whether it be IBM or Google or any other multinational, you're infringing on as many of our patents as we are of yours. And it really does open up that cross-licensing type of approach. And there's been really great examples. Originally, academically, I'm from the medical imaging side. But the reason there's only 3 MRI manufacturers in the world, or there were, was not because others didn't develop the technology, but because those were the 3 that decided to cross-license with each other to actually provide a full-featured MRI scanner. And everybody else got locked out. And maybe not in AI, but definitely in our field of quantum, there's a real risk that a very similar thing could happen based on the fact that now multiple large parties and even startups own very significant chunks of intellectual property.
Thanks. So with our time left, maybe one last question. Really interested in your thoughts on advice you would have if you were mentoring a company or an AI startup or a potential scale-up was coming to you to say, what would you do differently? How would you structure your IP thinking? IP is not always the be-all and end-all of every organization, but it's got a piece to play, and I'm interested in where you would direct companies coming to you.
I think it's very important, especially in a startup. Resources, cash is limited, but it can be very costly to not do it. If you wait, 6 months, 1 year to do it, your competitor might patent patent what you're doing, and obviously that's a huge risk for your company. So I think my advice for startups and early stage companies would be to make sure to invest in IP production. Make sure that your core team of engineers has a culture of IP. That way, when you grow the company, the different layers can also sync IP, and they can sync production of what you're developing.
I would add in, and it was definitely very informative for me, educate yourself. So I was lucky enough that early in my career, I got exposed to Syntech, which is, again, an imaging technology commercialization group in Ontario that put on a 2-day patent workshop. And there's many things you don't think about as a technical person endeavoring to start a company. The other side is also find a partner, whether it's a potential investor, whether it's a nonprofit, whether it's somebody from the BDC that can actually help you build a strategic plan for the early stages of your company. Because the things that you do early on really will set the tone for what the rest of your future will look like. And the biggest one that I've seen repeatedly with companies I've had the chance to work with, whether it be through the CDL or other areas, is rushing to incorporate and get started before clearing up the rights to the IP that they need to actually found the company on. And it creates massive headaches, limits investors they could have down the line. A little bit of work early on really does pay off a lot.
I would say the biggest thing with funding is hook up with an incubator. We hooked up with Launch Lab. They've got an excellent IP lawyer on staff, and that was free service from them. And then with that advice, went to Queen's, worked with the free IP legal team at Queen's, and we filed our first U.S. patent in November. And the cost to me was $200. It was remarkable. I couldn't have done it without subsidized funding. And that's my best advice is there's resources out there, use it.
Liz, you're not giving legal counsel, but your thoughts on what you advise early stage AI companies or even late stage to be looking at?
I'd say generally strategy, again, similar to the various other points. There's a lot of funding right now, especially for IP strategy determining. And if you can make a plan early on, then that will spare you a lot of headaches later, or hopefully spare you headaches later. And at least you'll know where the risks are and what is possibly going to be an issue. So in terms of strategy funding, of course, there's IP Assist, which the federal government is putting into play, and there's a variety of incubators and IP Ontario now as well. So there are just a lot of resources, and I really think that lack of strategic thinking is probably the core issue that we're seeing in this space right now with our Canadian small clients.
Thanks. So I'll maybe just take 30 seconds and wrap up. Thank you for your time. I really appreciate it. Your great insights. I think one of the pieces, if I go back to Geoff's, is why is IPON here? And part of the reason is we want to bring groups like this together so we can talk about IP issues, which sometimes are not always top of mind, but spending an hour or two to network and meet with other organizations or meet with other peers to say, how are you solving this problem? Where is there additional funding? Where is there additional support? We have this IP issue coming up. Who should I talk to? I just need to talk to somebody for half an hour before I engage my counsel because I need to know what questions to ask. So IPON Ontario is being structured to provide access to non-dilutive capital, starting at, I think, $25,000. I think for early stage companies, it's going to be, it's a significant piece because it's highly leveraged. And we're working with other funding organizations that like IP Assist and perhaps Global Affairs Canada on how we can make sure we're communicating and early stage companies are getting the best value out of funding. We're looking at the basic education programming, which is on demand. Again, we're not trying to make everybody expert, but just give a minimum level of awareness. And there's beyond us, there's other groups like IAC has advanced education programming. We'll have some different ones as well. So knowing that there's education, you can take your staff. You don't need to spend time onboarding new employees. You can just say, please just take that course. It's part of your onboarding process. And it is taken care of. And then the third piece IP Ontario is doing, which leads to my last question, is the mentorship piece. We believe one of the fundamental pieces in advancing organizations is have access to talented people that just need to give an hour of their time and can significantly help an organization. So we're looking at building that up. And on the flip side, we are going to be looking for some mentors, some IP savvy mentors. If you want to contribute to helping some companies move forward, we're hoping to put that into the ecosystem. So please talk to me about that after. So in short, IP Ontario is only a few months old, but we're growing fast and furiously, and love to have some additional companies come through the pipeline in the next couple of weeks so we can demonstrate to the Minister Dunlop and to the rest of her team that this is a need in the ecosystem, and also demonstrate some of the partnerships we have.